I think we can go ahead and get started. Thank you for those who are attending today for our 30-minute power session. Just a reminder, we do this once a month and we cover a variety of different mortgage-related programs and topics, as well as topics that are important to real estate in general. Today, we are thrilled to have Bryn Karas, who is owner of Juniper Law. Here in Northern Virginia. She's a personal family attorney and will be sharing with us some information about estate planning and how that relates to real estate, things that are definitely important for both mortgage originators and, of course, our realtor referral partners as well. So we're excited to hear what she has to say. Another reminder, this will be recorded. So for those of you that are looking for the recording, just know that within the next day or two, we'll send out the transcription and the recording to everybody so they can review it and pass it along with their friends and family. And from there, I'll go ahead and let Bryn get started. Thanks so much, Bryn.
Thank you very much for having me, Richard and Leslie. He introduced me. My name's Bryn Karas. I'm the owner of Juniper Law. I am based in Fairfax, but I serve clients throughout Northern Virginia and DC. I've been a lawyer for 15 years, but I've been doing estate planning for 3. And I absolutely love it because I get to have such a meaningful impact on people's lives and their families. Estate planning is all that I do. I'm part of this network of attorneys. That's Personal Family Lawyer. I highly recommend Personal Family Lawyers for anyone who's looking for estate planning attorneys. And with that, I think I'll just jump into the meat of the topic, which is how real estate and estate planning intersect and some of the top concepts that we all need to be aware of so that we can best serve our clients. So to start, estate planning has 2 main purposes. It's planning for your potential incapacity and also planning for our inevitable death. It's about managing and transferring assets with clarity and ease. At least that's one piece of estate planning, is about making sure that assets get to where they need to go with as minimal fuss and cost as possible. And when you think about it, like, what is the largest asset that most people have? It's the house. So there's pretty clearly going to be a tie there that you as real estate professionals can bring some value to your clients. As they acquire property, you can help educate them and highlight things for them that they might need to talk to an attorney about. So just as an overview, an estate plan can affect real estate in a variety of ways. It will determine who inherits the property and how. What are the terms that will apply to that property when the person inherits it? The estate plan will determine who can sell the property and when. And I'll get into that a little bit later. How many owners of the property are there to begin with? And then how many owners will there be when those owners pass away? Let's say a married couple buys a house and then they have 4 children. If they don't have a complete estate plan, then those 4 children, when the parents die, and each inherit 1/4. And then those 4 children are set up for some kind of a conflict, aren't they? Because you've got 4 equal owners of real estate. And one of the things that I really try to do and that estate planners should be doing is trying to spot areas for potential conflict before they occur so that we can prevent that. The other thing to keep in mind is that if 2 parents own real estate and they have minor children, if the children are minors when they inherit that real estate, the court will assign a guardian over the real estate until the child turns 18. There are layers of problems here that people can end up in if the worst happens. Now, of course, we all like to believe the worst is not going to happen, but being in the line of work that I'm in, I unfortunately hear about the people that this happens to. And so I really strongly believe in putting the plan in place early so that the owners are informed about their options and about the risks of doing an estate plan or not doing an estate plan. All right, so moving on. How the property is titled has a big effect on the rights of the owners as well as their heirs when the owners pass away. So you're probably all familiar with tenants by the entirety. That's pretty standard in Virginia for a married couple to take ownership as tenants by the entirety because it provides some creditor protection. If they create a revocable living trust to prevent some of the kind of bad things that I was describing that can happen, that creditor protection that attaches under tenants by the entirety will still be in place if they create a revocable living trust, which is really, really wonderful nugget to have. And then if you create a trust, you can also provide extra control and flexibility over the assets in case the owners become incapacitated or pass away. A trust also provides for probate avoidance. So if, let's say, a family does have minor children, if they can leave their home to benefit their minor children, but appoint a trusted loved one to manage that asset for them, for the kids, without having to involve the court system. It really smooths the process. A transfer on death deed is another method of avoiding probate. It's not quite as foolproof as a revocable living trust. Not that a trust is completely foolproof, but you get what I mean. And an LLC is another valuable tool that can be used to provide liability protection for those who have investment property that they are renting out. And it can also provide privacy. An LLC, a trust provides a lot of privacy, but not perfect privacy because the name of the trustee is going to have to appear on the deed. And as you probably all know, deeds are public information. If someone really wants privacy about who owns their property, they're going to want to take ownership directly into an LLC. And if they set that LLC up properly, they can have complete privacy about who owns it. Can be useful. I had a call with someone recently who wanted privacy about where she lived because she didn't want her ex-husband to know where she was living. So that's just a little nugget to have in mind. So who can sell a piece of property? I mean, the owners can sell. But if the property is in a trust, the trustee or trustees of the trust can sell. Now, there might then be a question of who is the proper trustee, and you probably do want to consult with a real estate attorney on that. I mean, my answer for everything here is going to be check with a lawyer, but this is just an overview. If a piece of property is owned by individuals who are incapacitated, then the agents who have the power of attorney, they can sell property if the power of attorney has been properly drafted. So that is another thing you might want to check with your lawyer about. If an owner has died or the owners have died and the estate is currently going through probate, the executor will be able to sell the property, and they don't need to finish probate before selling the property, most likely, but they will need permission from the probate court to sell. So estate sales are always lengthy, always a little bit more of a hassle, a little bit more paperwork, and a little bit more headache for everyone. But so those are going to be the key people involved in the sale. Oops. And now I want to go over the idea of cost basis, because this is another element that can be affected by how an estate plan has been designed. People often put their child or their children on their home's deed in order to avoid that home going through probate. This is a bad idea for a couple of reasons. One is that the cost basis of a piece of property will be adjusted to the fair market value on the date of the owner's death. If the home is owned 50% by mom and 50% by the child, then the cost basis is only going to get updated by 50% and not to the full market value. If instead the child inherits after the mother died, they get the full step up in cost basis and potentially avoid thousands of dollars in federal taxes. The other thing to know is that if a child has ownership in the parent's property. And this is true both for bank accounts and real estate. If you just put your child the on the title, then the child has an ownership interest. The child owns 50% of the property essentially. And this makes that property vulnerable to the child's creditors, to any lawsuits, and to potential ex-spouses that the child might have in the future. So it's important to understand these impacts of this would be a very basic way of doing an estate plan, and it's not guaranteed to be a bad idea, but there's a much higher likelihood of things going poorly if you just put your child on your property. So these are just some concepts to keep in mind as you talk with clients, about things to think about when they buy real estate. I mean, when people buy real estate, it's also a really good time for them to think about doing an estate plan, because it's a significant life event, as we all know. They're making an investment, they're putting down roots, perhaps starting a family, and protecting that family is, going to be top of mind, and an estate plan is a really excellent way to do that. So it's just a talking point to have in mind as you work with your clients. I want to draw your attention to that this week I published a blog, and here's the website, juniper.law/blog. And it's all about what happens when you inherit real estate and some things to keep in mind. You might want to take a look at it. It talks about insurance considerations, logistical considerations, and some just what are the things that a person needs to do if they inherit property. And it's just a coincidence that I published this week. So I hope you will all consider me a resource. If you'd like to chat about any of these ideas or about a particular client that you have in mind, I'd be happy to do that. And please reach out. My email address, my website, and my phone number are on the screen. And I'm happy to answer any questions and talk with you more in the future. So are there any questions now that I can answer?
Yeah, thanks so much, Bryn. So anyone that has questions, you feel free to unmute yourself, or you can type it in the question and answer section, and we'll field it to Bryn. I see Kathy has one, though. I'll let you go.
I do. Hi there. Thank you for this good information. I recall a few years back, I had a situation where husband and wife had a trust, and the husband passed away, and then the wife called me to sell the home, and it was just past the 2-year mark. And actually, I wonder if you can answer this, if it's more for an accountant. And I believe that if she had sold the house in the first 2 years, she would have qualified for his capital gains deduction. But since she waited more than 2 years, she didn't get that. And I feel like it was tied to the trust somehow. Are you aware of that, or?
No, I'm not. It might have to do with the way the trust was drafted. Was this do you remember the value of the home? Were we talking millions here?
It was a million, it was a home they had built themselves in 1972, for, I don't know, $38,000 or something. and it was in Clifton, and it ended up selling, right, in the 900s many years later. And there was a trust. And then I remember that the capital, there was something about this 2-year mark with the capital gains, and it made me think, oh my goodness, I should alert my clients. At my age, unfortunately, a lot of my peers were starting to lose our parents, and if they've lived in their home forever, that's a big impact. And I just kind of thought, oh, this is something I should dive into a little deeper so that I can explain it to people, and I haven't.
Yeah, unfortunately, I'm not aware of what you're talking of. My understanding of what should have happened in that situation is that 50% of the house should have received a step up in the cost basis.
Uh-huh.
So, and then she would also get a $250,000 deduction because there's like an exemption for the first $250,000 of an increase in cost basis for residential properties. So there only should have been, for maybe $250,000 that should have been considered a capital gain. That's still quite a chunk of a capital gain.
Yeah,
though.
and I think if she had sold previous to 2 years of his death, she would have been able to take his capital gains deduction.
That may have something. No, yeah, I don't know. Now I'm going to research it and potentially get back to you.
Yeah, let Leslie and Richard know.
Okay.
I might follow up and see what I can find out too, and I'll reach back out to you.
I'll ask my CPA friends too.
Yeah.
We're going to say, Kathy, for our next power session will be with the CPA. So
Yeah.
that might be a good one to get that question answered.
I don't know a lot about trusts, and I guess every situation is different, but I feel like sometimes I encounter like a husband and wife with a single trust, and sometimes I encounter that in their separate trusts.
Mm-hmm.
What's the reasoning behind that?
So it will sometimes just it's going to depend upon the family dynamics. Sometimes it will depend upon which attorney they used. Some attorneys just stick with 2 trusts for a married couple versus 1. But one typical reason why I might have 2 trusts for a married couple would be if they had different beneficiaries. So if you have a blended family where, husband and wife both have children, but they don't share children, or maybe they do both. Maybe they each had children and then they had children together. Then it might be wise for them to have 2 separate trusts to make sure that their children don't accidentally get disinherited. So the design piece of this is always, as you said, it's very has to be customized to fit the dynamics of the family.
Okay. Makes sense. Thank you.
Yeah. You're welcome.
And does it make sense when you're writing a real estate contract for the realtors on the call? You write it if somebody's has a trust and they say they want to put the house in the trust name. Okay, they already have the trust in place. As a real estate agent, Kathy, since you're talking, do you write it in their trust name as the sellers of the property or the buyers, however you're on whatever side you're on?
Yes. I'm in a parking lot doing this. I didn't want to miss this call. Sorry for my technical difficulties. Yes. If they've already got a trust, then we will write it in the name of the trust.
Do you collect the
trust? Provide a copy of that to the title insurance company, and probably you, right?
Yes, we would need to see it as well if you're going to go that route. And sometimes it's easier. It just depends on the people. Just for the real estate agents on the call, from a lending standpoint, sometimes it's easier. We'll tell people, yes, you want to hold it in your trust, but then they have to provide a whole copy of the trust, and then oftentimes there's an attorney opinion letter that costs money that they have to have done before it can actually be recorded that way or approved that way from the lender standpoint. So sometimes it's easier, sometimes it's cheaper just to have them close in their individual name and then just turn around and put it into the trust name right after. So for our purposes, it just depends on the couple or the people that are coming, whether they, want to go ahead and go through the extra hassle during the loan process and have it put in the trust name when they close, or if they just want to do that after. So there's not an additional expense, at least coming from the lender side of things.
It can be worth it if it's a married couple to first title it as tenants by the entirety and then into the trust, because then the tenants by the entirety protection carries into the trust. If you put it directly into the trust for a married couple, there won't be the creditor protection that TBE can provide.
Oh.
Yeah.
Oh, that's really good to know.
It has to be a 2-step process if they want that creditor protection.
That's a big deal.
And when it comes to,
that's interesting.
Yeah, it's the way the law is drafted. It has to be first TBE. And it can go it can go
Yes.
from owned as tenants by the entirety to then owned by one joint trust, or it can go to then owned by two individual trusts, as long as the spouses are the trustees and the beneficiaries of those trusts, that protection will extend to the new ownership in the name of the trust. And then for the
Can
lending
you,
part, I'm not as familiar with the lending part, but my understanding is that if they purchase it as individuals and then place it into their trust, that the mortgage should not be affected.
Correct.
It's because of the Garn St. Germain Act. Yeah.
This may be a rudimentary question, but revocable versus irrevocable trusts. I've never seen an irrevocable trust, but I'm always told for lending purposes, it always has to be revocable. So I guess maybe a quick overview of that.
Sure. Revocable means changeable. Irrevocable means unchangeable. So if you create an irrevocable trust, typically what a person is doing is they're trying to take some money and remove it from their ownership. So they're creating a charitable irrevocable trust, means that what they give to that trust is no longer in their control or power. So revocable living trusts are what are typically used for estate planning purposes. I think of irrevocable trusts, they usually have some other motive or some other use, such as planning for needing to go on Medicaid in the future. You can create a Medicaid asset protection trust, which is irrevocable. Or you can create a irrevocable life insurance trust. These are kind of tax strategies. So usually irrevocable trusts have some kind of ulterior motive that will vary from family to family. But the bulk of what people own is probably going to be left for a typical family. We're not talking about the ultra high net worth families here. We're talking about your typical family. Will be in a revocable living trust.
Thanks for explaining that.
Sure.
So no give backs.
No give backs. Correct.
Are there any other questions?
Other
Can we
questions?
can I just go back to, if someone has purchased their property in the trust, so it was not done as tenants by the entirety, is it easy to go back after and have it changed to that? Because I'm just thinking, I've written
You've written
offers
them.
in trust names, in the family trust, and now I'm thinking back on those clients. Do they
And you're
not
like,
have
how
TDE?
do we give them more creditor protection? Yeah. If they would have to, I think it could be done. They would have to execute 2 new deeds by transferring it out of the trust into their names as tenants by the entirety, and then wait a day and then put it back into the trust.
Okay. Okay.
Yeah, that's a really good nugget of information. Bryn, just in general, what does a full estate plan in general, just average cost if somebody were to put that together?
So trust-based planning, which is a lot of what we're talking about here, is probably somewhere between $4,000 and $8,000 around here. It will depend upon the features of the trust that you choose and the level of design that's required. I really think of an estate plan, if you're buying a home, I mean, of course, there are a lot of expenses that go into moving and buying a house and insurance and everything. But it's a really great investment that you can make when you are young and healthy, and then just keep it up to date over time. This is how I try to talk to people about estate planning, is that if you do it when you're young, it's less scary and you kind of build a muscle, and for that entire time you're protected. And your family has levels of protection that they otherwise wouldn't have. So yeah, I mean, it is a hurdle for some people, both emotionally and psychologically to do, and financially. And it's generally about $4,000 to $7,000, $8,000. Will-based plans are cheaper. They're probably closer to 3,000. 2 to 3.
And would that just mean less protections with a
There's a
will
lot
versus
less
a trust?
there's a lot less flexibility and protection in a will-based plan. Will-based plans do not avoid probate, and probate avoidance is usually one of the big goals for families that have, you know, any chunk of wealth. And around here, if you're buying a home, you have some assets, because we all know this is not the cheapest place to buy a home in, is it?
Can I ask another question? This is my last one.
Sure.
Do trusts like transfer across states? So like if you have clients that are moving out of the area and purchase a new home in a different state, what at that point do they need to do with their trust? Like, I guess it has to be.
Yeah. So somewhat, and now that you've raised this, I'm actually going to answer two different questions. One is that, let's say a family here in Northern Virginia, they create a trust here in Virginia under Virginia law, and they have a house here in Springfield. And then they buy a house in Alaska for vacation purposes. They can put that Alaska real estate into their Virginia trust, and that will allow that house to not have to go through probate when they die. So anyone who owns real estate in more than one state, it's definitely worth it to create a trust-based estate plan, because if you don't do it that way, then that family would have to go through probate in every state where real estate is owned.
Oh my goodness.
So that's another really valuable ticket or piece of information to share with clients who might be, you know, buying vacation homes. Or I've known people who buy a condo for their kid when they go to college, and it becomes an investment property. Like, that's another situation that I think is pretty common. But the question that you asked was, let's say the family creates a trust here in Virginia, and then they move to Florida. A trust can still work if they move. It's often a good idea to have an attorney in the new state take a look at it. And they might decide that it's worth redoing based upon it. Often a trust, an estate plan should be updated or at least reviewed every 3 to 5 years. And so if someone moved to a different state, I would highly recommend that they sit down and with an attorney in that state to look at it. An attorney will probably charge a flat fee, maybe $750 to $1,000 to review it and go over it, and just to make sure that it will still serve their purposes. The trust will still work.
Right.
It's just, and Virginia law will still apply, but it does get more complex when people jump around to different places.
Makes sense. Thank you. And that was very good information to know about investment properties in other states.
Yeah.
Appreciate that.
Ooh, Michelle is typing.
Thanks.
You're very
Michelle.
welcome, Michelle.
Okay.
Well, we'll do one last call, I guess, for any questions that folks might have. We're here at the end of our 30-minute session. Anybody else have a quick question for Bryn? Going once, going twice. All right. Well, thank you all for joining today. Thank you so much, Bryn. As Kathy said, I mean, this was a wealth of knowledge. I learned a ton of new things in 30 minutes. So that was a fantastic presentation. Thanks so much, and look forward to having you back in the future.
Thank you so much. Nice to
For
meet
those
you all.
attendees, For those attendees, just a reminder, we will be sending out a copy of the recording, so keep an eye on your inboxes. That should be coming out to you here either later this afternoon or tomorrow. And if you have any friends or family that you think or colleagues that might be interested in this information, you'll have the link that you can forward on. And if anyone has any questions for Bryn, you see her contact information there on the slide. We'll make sure to send that out as well so that you can reach out to her if you can be of her use her services.
Thank you all.
Thank you.
Wonderful. Thank you very much.
Thank you so much. That was great. Bye-bye.